So I've just finished reading the section X of William Pynnes' brief Calendar of Parliamentary Writs, or it's basically the last of a 4-part series. And I don't know what the third part is. I really want to know what the third part's about. I've read the first part's available online. It's mainly about summoning parliaments and issuing letters and writs, basically, which are out to members of, basically the House of Lords or the bishops, abbots. It's basically for calling and assembling parliaments. The second part, some of that's online. Now, I don't know what the third part's about. I haven't found any trace of the third part. The fourth part is the one that I'm interested in, and I've now read the section X, which is really important because this is all about privileges. So that's actually the most important book to do with petitioning, because it's the general view of privileges, and it does touch upon petitioning around between 1661 to 1664. 1661 to 16... So William Pynnes, I think, judging from his first book, I think that these books are quite influential because he was locked up, remember, in 3 castles over a number of years, right? Although he did end up as an MP for Bath, he also had a doctorate in law. He went to Lincoln's Inn, right? He had a qualification in law. So he was a scholar of law, and he's wrote his books from Lincoln's Inn. So his attitudes were kind of like really sort of middle view, but I think he ended up sort of being an enemy of the Cromwell government, but he was a supporter of John Pym. Although John Pym was early on in the English Civil War, towards the start of it, not towards the end of it. I just wanted to basically set out what I found from the book, basically, from reading the book. Effectively, right? So William Pynnes, he actually, I think his first book actually resulted in causing or contributing towards causing the 1661 Tumultuous Petitioning Act, because William Pynnes was never a supporter of kind of like, public misuse of rights and, these huge tumultuous disorders and so forth. He did believe in right to petition and mesne process and, acting with the agency of Parliament, right? He didn't disagree with that at all, but he didn't agree with the abuse of it. And really, basically, preventing parliamentarians from going into Parliament or, assaulting them or anything like that, right? I'm not saying that anyone attacks MPs at the moment or prevents them going to Parliament, but, with the whole issues from the Civil War, obviously, Pynnes was very sceptical of, powers, but also he also was very critical of MPs abusing powers in Parliament as well, when they don't serve properly. Like Matt Hancock basically went off to the jungle in Australia, and neglected his constituents. That's an abuse of parliamentary powers, basically not serving us properly, right? In a way, the petitions have been put on a sideline, really, and the importance of them has been reduced in the House of Commons, and now we've got big business and lobbying and so forth, when a lot of the petitions served as lobbying because people were their own business bosses and guilds and so forth, rather than it all being like, Amazon and Microsoft and, Bill Gates and so forth owning everything, and all these big team players and investors, Shell Oil and all these big companies are now lobbying the government and even prosecuting the government. When it was less ownership by these smaller, bigger bodies. I mean, sorry, when it wasn't dominated, right? When it wasn't, what I meant to say, when there was less ownership by smaller people, right? Like now, because everyone basically works for these big corporate people, and they don't really have a say in Parliament, really, to do with employment, right? Or taxes, or how the companies are being taxed by the government. That's not really their business now. But when they were their own business people and their own companies and so forth, and guilds and skilled people, they communicated with Parliament about, taxes and importing products and all kinds of things like that was done by petition to Parliament, whereas now it's been taken over mainly by big companies lobbying, right? And that's really why we've been put to the side. So, Prynne was also sceptical about privileges of Parliament, and he laboriously went through to the Tower of London and went through all the rolls. Now, I don't know if he actually went through all of the petitions in the House of Lords, because I found some which touch on a lot of servants getting privileges or arguing for privileges, and there's some things in his book, which he says at the very end of his book, which is what got to the last bit. He says if there's anything wrong in this book, then he apologises for it, but he's done his best to get it right. So I don't know if he'd read every single one of those petitions, which Professor Jason Peacey, now in modern times, has transcribed from the House of Lords, because we don't have the House of Commons ones because they all burned, right? So there are a few records from after the burning of Parliament up till 1947 on a microfilm somewhere, which you can... but currently Parliament aren't offering access because they're complaining that they're moving everything, right? So William Prynne, right? So when he does these books, he's really going through the Tower archives, right? And he's also doing a lot of work at Lincoln's Inn, and he's basically, he's meant to be a competent practicing lawyer, right? But he gets punished for his work. But his work also, like I said, this is the most important part that I basically wanted to impart to you, which is that his work influenced or was a causing factor. When you read it, you can understand from what he's saying in this getting published, right? What he writes in his books, and there's not going to be that many people writing on the subject, obviously, at that level at the time, publishing books, right? So it was something quite significant. It's clear from all his books that all his books have got a lot of influence on a lot of things that happens in Parliament as well. Just like, Henry Brougham later on in the later 1800s has also had an influence and, effect on, Baron Denman and Erskine May as well. So they're all kind of like, these are all people who have used each other for sources or have had influences from each other, right? So we get this Tumultuous Petitioning Act, right, which is made in 1661, right? Now, I think, obviously history plays out over a period of time. It's clear to see now, anyone who's aware of what's going on now, that we're all kind of engaged in a narrative which is playing out and unfolding, but it's taking a lot of time. So, we all had the pandemic and we're in lockdown, and that happened to everyone. And then, there's Extinction Rebellion and Just Stop Oil and all these other groups are protesting, and then time goes on and now we're out of the pandemic. But, it's getting on towards 5 years now nearly, right? So that's 5 years, so, and we still haven't really got any resolution. And, you've got all these changes in government in America, like, Donald Trump gets in, and Biden administration are out. So these things, like, take time, and they pass over time. And I'd have thought that, back then, with transport is slower, and there's less communication. So things happened a little bit more slowly, obviously, then than they are doing now. So what I'm trying to say is William Prynne definitely had a part to play in the creation of the Tumultuous Petitioning Act, right? And then, so he actually dies in 1669. Now, the fourth part of the book was done, I think, 1664, the part I've just read, Section X, which is the section that I wanted to read, which has got all the information to do with the privileges in that section, right? Now, he wrote that book after the 1661 Tumultuous Petitioning Act, but also when he was an MP for Bath as well. So at this point, he'd been through quite a lot. He'd been a young student. He'd grown up through the Civil War. He'd actually himself been, a victim of mutilation. He'd been at the bad end of the law, been locked up in castles over a number of years. He'd had his ears cut off as punishment. So he's been through quite a lot. And at this point, when he's done this fourth part of his book, he's actually himself contributed towards the Tumultuous Petitioning Act, which that's obvious. I mean, if you want to challenge me on that, you just have to understand, how important his book was at the time and the things it was saying in it, right, and so forth. Now, 1664, he's actually in Parliament. He's an MP when he's writing about privileges, so he's got access to, documents and so forth. But he wasn't a member of the House of Lords, remember? So he might not have had access to the petitions in the House of Lords, because I don't know if he will have been allowed to go in there or not, because it's separate, isn't it? And they've got their own separate privileges, and those petitions might not have been in the Tower of London at that time, right? That's what I'm guessing. So he might not have known absolutely everything. He says he went through the rolls meticulously and trying to find, evidence and instances of. He wanted to find what the privileges were being used for and what kind of claims were happening and what kind of writs were being made, which is what I wanted to know and find out, okay? Because a lot of it was done by writs, and then they kind of banned them and stopped them doing writs, but then they could get a writ from the Speaker, but they stopped other members from writing them and so forth. So 1664, he's writing about privileges right now. At the end of this section X, this is actually really important, right? So this is when he's been serving in Parliament. At the end of the book, he writes some things about, because sometimes Parliament could put an act of law through for someone's privilege, but only for usually for individuals, right? Now he does. There's some really beautiful quotes at the end of this Section X, and this is really where it got really interesting towards the end, because he's saying things in that book, in the fourth part of the book, which are going to, in my opinion, have a very, very strong direct effect and influence on the 1688 Bill of Rights, right? Because they do end up making a law. He's talking about getting laws put through Parliament, for people's protections and privileges and so forth, and petitioning. And that's what actually ends up happening. They actually end up giving us it actually in the Constitution, in the law. Now, those books are, those books, those writings are actually monumental, but not a lot of people know about them. Now, the thing is, this is the thing, right? So, he dies in 1669, right? Now, the year later, in 1670, okay, is when we find William Prynne. He's in the streets in London, and he gets accused of a tumultuous assembly, right? So William Penn and William Prynne are alive at the same time. Now, it's funny that their names sound similar, William Penn and William Prynne. In fact, if someone said William Prynne, you might think that they could have mispronounced William Penn, right? Now, but this is the thing. Now, in this tumultuous disorder, this prosecution case at the Old Bailey in London with Samuel Sterling, the mayor, right, whose vocation was a brewer, by the way, right, Lord Mayor of London. So that case is that case gets a lot of publicity because they've got the whole thing with the plaque in the Old Bailey on the wall, but they make it to be all about the jurors, the jurors getting locked up, right, and about the conscience of the jurors to make their own conscience up, right, and they actually end up making these courts of conscience later on, but the actual real, I've said this in other videos, but the real actual important principle in that case is whether or not they were acting with agency or not, because if they were acting with agency to a cause to Parliament, then they were meant to be protected, but obviously not if you've got over so many people, unless you get consent. But the jury said they weren't acting with agency, which basically means that they weren't doing a petition. They were just in the street having a gathering. It wasn't anything to Parliament or to the King, to either houses of Parliament or the King, right? So, and that's the argument now, what they're having with all these campaign groups, are they acting with the agency of Parliament or not? But instead, this Defend Our Juries place ends up talking about the jurors, the right of the jurors to decide on their conscience. But we don't really hardly have juries anymore, only in Crown Court. They're supposed to be in the Magistrates' Court because you're meant to be judged by your equals, and the magistrate definitely is not thinking that he's our equal when he's like stand up, sit down, right? So, now what I wanted to say is that the William Penn trial is, he does go over to America. His dad was a captain, on the King's ships. And so he knew all about boats and sailing and going out probably with his dad on boats, maybe. I don't know. But he was familiar with it. He went over to America and he was active in the colonies and so forth. He even meant to have started some of the colony activities over there in some areas, right? And then I think this is when he's got a connection to Pennsylvania, the name of Pennsylvania and the whole thing with Washington, right? And it's tied in to the foundations of Washington, right? That's why, the White House and the whole kind of American Constitution and everything like that. I think William Penn was active politically over there, right? But he did come back here. Now, the thing is, William Penn and the whole kind of Pennsylvania spin-off and the whole White House and the whole Constitution of America and the whole Old Bailey plaque on the wall, that is the history which gets all the spotlight, right? It gets all the acknowledgement, it gets people talking about it, and it gets people learning about it at schools, okay? And it's funny that it's William Penn, not William Prynne. Now, it's funny that, it's just amazing that happened a year after Prynne passes away, but they will both have been alive at the same time, right? In William Penn's trial, he does talk about Magna Carta, but he doesn't actually mention anything about William Prynne's books or the work of William Prynne, okay? But he does know about Magna Carta. He probably will have been quite well educated, but he definitely didn't study law. Obviously, if his dad's a sea captain, he will know about Magna Carta and the Great Charter because he'll have been well educated, if his dad's a sea captain, right? So the William Penn really takes all of the attention, particularly when it comes to petitioning and tumultuous disorders. And even now, most of the campaign groups like Extinction Rebellion, Just Stop Oil, and This Defend Our Juries were claiming to be interested in William Penn and claiming to be interested in the Old Bailey plaque and all that kind of thing. I don't think they fully appreciate and understand that story and its part in history, but for sure, right, you need to completely and fully understand that. And then when you understand that, then you need to understand that has actually even taken the attention away from William Prynne and William Prynne's writings and his books, because they're the books that actually impart the real serious stuff about, keeping the MPs in order, what the MPs doing wrong, are they breaching the privileges, can we prosecute them in the courts, what should they or shouldn't be doing in Parliament, what the rules of Parliament and all these parliamentary writs and so forth. I think there are some things that William Prynne missed out in that, but he's a guy who's got a lot of writing I'm probably not going to read all of his writings. I've got another 3 things lined up that I want to read from his, and I've written quite a few of them. And there's also that 3rd part of his series is missing. I don't know what that's about. But this 4th part is, out of all his work, it's probably the most important one that I definitely am happy that I found and glad that I found. He actually has written. He's written quite a bit about, in the famous William Cromwell scenes in the movies. When the king goes into Parliament, and all that. He did write some accounts of that himself. That gets a lot of history. That gets a lot of attention. The whole Oliver Cromwell story. There've been films made about it. There haven't been any. I don't think there's been a film made about William Prynne. I might be wrong about that. But whatever the case, right? These books are important, but they're very, very less known of. Now, after William Penn, then we kind of go from William Penn going to America and the colonies, and so forth. It runs into the Glorious Revolution and the Bill of Rights. And I think William Penn, not Prynne, William Penn is just about alive when they actually do make the Bill of Rights eventually in the constitutional law. I think he passes away in the early 1700s. Obviously the American Constitution is a little bit after that. But what I'm saying is William Penn has a little bit to play in kind of like the pre-backstory, over in America, really. So William Penn is alive. He suffers this, tumultuous assembly. He's a victim of one of these tumultuous assembly charges, right? But then they make in 1688 they make this law. Now, this has been the argument ever since. It's the right to petition without being prosecuted. Petitioning is very important, or you wouldn't have such an important right and protection. So, to say that petitioning has been put on the back burner in Parliament, and to say there's a petition bag behind the Speaker's chair, and to say that, it's important enough that it's protected, it should never really be regarded as a very insignificant or unimportant thing in Parliament, to submit petitions or to get the signatures and do it. It should never be regarded as, insignificant or unimportant, even though we're electing these people to go represent us, right? They're still representing us nonetheless. So with this whole kind of, so we've got these characters who are in Parliament in 1688, besides, William and Mary, William Orange, and we've got like Pollux-Fen, who was the MP from Exeter, I think, and he was a Lord Chief Justice at the time, right? So, all these people. Now, I think, therefore, now that I've read William Prynne and understood how important William Prynne's work and books were, right, then I can clearly see that his exact wording and his exact phrases and some of the ideas that he put in there and some of the things that he said in his books absolutely have been contributory to the 1688 Bill of Rights and the idea behind it, and everything that happened leading up to it. So it was like, a long series of events. But to say that William Prynne wrote his book in 1664, and then by the time he dies, we're going into the 1670s and through William Penn, and then we don't get the Bill of Rights actually till 1688. But his book will definitely have been a very important book all the way through all that, right? And he himself contributed towards the Tumultuous Petitioning Act, some of his ideas and work. So, and also the events of William Penn also did tie into it as well. So it's great to read and understand and see all these influences that happened through, we had the Civil War, the 1650s, and then 1660s, then 1670s, and then 1680s, and then 1688, right? Okay, so it's all connected. It's all like everyone is engaged and influencing the whole kind of thing unfolding, right? And it's very, very. It's really, really informative to read the end of that section X because he's almost setting up for the 1688 Bill of Rights. Although I don't know if William Prynne would have supported it or not. And also, he's saying in his book that that he doesn't think that people should be prosecuted for breaching privileges of other people. But they did end up making it illegal, so it's unlawful, right? Illegal prosecutions by the King's Bench and illegal prosecutions for petitioning. So they actually make it illegal. So the 1688 Bill of Rights, William Prynne didn't think that he'd found much evidence for people actually being punished or prosecuted for breach of privilege. There were one or two cases, but generally he didn't think that it was a principle. I think they've definitely, in the 1688 Bill of Rights, they've made it illegal, right? And from reading through the House of Lords petitions, I'm glad that I found, well, actually, Professor Jason Pesey and Dr. Brodie Waddell from the London University Research Group, who they did all their work during the lockdown, right? They transcribed a lot of petitions that people would have been able to get access to them and they would have been able to read them, right? But it was in like very hard to read writing because it was all in very old-fashioned joined-up writing, okay, in people's personal handwriting, and so that research group actually transcribed a lot of the petitions into text, basically, right? And then put it on a free website so you could like look through them all, okay? So reading from, there are thousands of them, so I'm not going to be able to read every single one. But what I did is I was able to search for them all and get all of the ones which mentioned and talked about privileges and protections, right? So there was about, there was like a few hundred samples, okay, specimens. So I read those ones because they're the ones that talk on about privileges and touch on the matters of privilege, right? Which is found out about the Sheriff's Gumpty counter, which William Prynne also mentioned in his book that I just read last night. And the fact that these writs of privilege existed, and also that if people broke the privilege, sheriffs could get arrested or prosecuted for arresting people illegally, right? Now, William Prynne, when I've got to the end of section X of his book, he doesn't believe that it was that people should be prosecuted for illegal prosecutions, right? Well, they weren't illegal at the time, right? It was just a breach of privilege, okay? It wasn't actually illegal at that time. Some people had been punished for it, okay? But he said that he hadn't found much evidence for people being punished for it in the Tower of London rolls, okay? Or in the Parliamentary Archives. But I'm starting to think now that maybe Prynne himself, because, he was an MP for Bath, but he hadn't always been an MP, I don't think that it's starting to look like that he might not have had access to all of the actual original petitions, particularly the ones in the House of Lords archives, because he might not have had access to the House of Lords. He might have just been going from what he found in the parliamentary rolls in the Tower of London, right? Because there's lots of specimens in the there's lots of specimens in the House of Lords which say that lots of people were punished, sheriffs were punished. Although there's a brilliant story that William Prynne talks about at the end when part of the House of Commons sent the Black Rod to go get someone released from prison, and the sheriffs wouldn't release them, and they ended up having a brawl or something. That was quite entertaining. And then it got raised up to the House of Lords. That was quite an interesting story at the end of the section. But so I don't think that necessarily he knew all the things that had been going on with the House of Lords and the servants and the Lord's servants and them using the Black Rod and so forth. I might be wrong about that, but it's looking like he might not have seen all the petitions. The one thing that we should note is that at the time, William Prynne would have had access probably to all the House of Lords, House of Commons, not House of Lords. He didn't have access to House of Lords, I don't think. Let me just say that again. It's a shame that when William Prynne was alive and Parliament had not yet burned down until the 1800s, he would have had access to the House of Commons petitions and all of the things that happened written in those, that was recorded, written in them. If he would have known that Parliament was going to burn down in the 1800s, he probably would have, done something about, maybe writing something about those petitions and matters. But there were apparently hundreds of thousands of them. There were apparently millions of them. I think there are over 1 million even on in this record. This existing record, which is a parliamentary sort of notebook or registry. It's a registry of petitions from the House of Commons, which were submitted after it burned down and all the previous ones were destroyed, up till around 1947 and 1948 when they stopped throwing them away, right? The originals were destroyed. But they took some information down from them, general information, like what it was about and, so forth. So that's the information that we've got, which you can research. But at the moment, they're moving Parliament around and they're saying that we can't access it. I think there are some other educational organisations that have it, but you got to pay to join it. So I've not paid yet. So that's what I actually want to get hold of and find. So William Prynne, he didn't believe in, he might, I don't know whether he would have agreed with or believed in what Extinction Rebellion and Just Stop Oil are doing, right? That was the type of thing that he didn't support or didn't agree with. And also that he didn't think that people should be punished for a breach of privilege. But he did believe that it should be enforced and upheld by the courts, and he did believe that MPs shouldn't breach their own privileges, that MPs should have a certain conduct and behaviour, unlike Matt Hancock, kind of like, more concerned about being a celebrity than serving their constituents. He probably wouldn't have agreed with Nigel Farage and Tice with GB News, or Boris Johnson's newspaper articles and so forth. A lot of these MPs now want to, like, Liz Truss, they want to be a celebrity. They don't necessarily want to be a politician, just, work in Parliament, And a lot of the Parliament staff get it wrong because they've been miseducated or misled or groomed by predecessors, and it's passed on. And when MPs join, they're members of parties, and it's all under like a whipping order. And this is where you got to challenge these people. You got to challenge these clerks of the Journal Office. You got to challenge these, skeleton staff. Part of the furniture people of Parliament. You got to challenge the House of Lords members. Lord Falconer, who was in Tony Blair's government, supposed to be in charge of constitution and democracy. I've questioned him on, what is this Control of Advertisements 2007 Act all about? This exemptions in the in the Class E and F section. He knows about it because he was one of the people in charge at the time, Lord Falconer. We need to press him about that, things like that. But anyway, Prynne definitely wanted to uphold the rights, but he was kind of like a moderate person, kind of like in between. So when we come to finding the Bill of Rights, for someone who just finds that 1688 Bill of Rights and reads it and, what is it about? What does it mean? Like when I found it and I read, it's a right to petition without being prosecuted, and prosecutions are actually illegal against you, right? So there are actually instances in those petitions in the House of Lords archives when people have been punished. I definitely think they were punished after the time of William Prynne, after William Penn's time, from 1688 onwards. I think it was actually illegal. It is meant to be illegal to prosecute, and that's why I don't think the Crown Prosecution Service like it. But it's legitimate. That's what it is. It is mesny process for petitioning. It's using parliamentary agency. And in fact, when we then go through the 1700s and then into the 1800s, you see when after Parliament burns down, because we got the Luddites, because William Prynne wouldn't have agreed with the Luddites, what the Luddites were doing, smashing up machines. They were really pushing the boundaries, but they had the 1688 Bill of Rights right to petition, okay? So the thing about the Luddites is they were complaining about the minimum wage, okay? And this is what actually really led to the demise of petitioning about taxes and imports and things like that, because it slowly fell out of the public remit, out of the workers' remit, into the factory owners' remit, and into the corporations' remits, and into the investors' remits, and into lobbying, right? And it no longer became a subject for the subjects, subject for the workers. In a way, you could say, really, like, the Labour Party, don't worry, we'll take care of it all for you. Why do you need to petition the government when the Labour Party are looking after you? Supposedly. So the Luddites really, I think, after the Civil War, after the right to petition was made, it's a proper thing. It's a legitimate thing. It's about privileges. It's about measuring process. It's about casework to Parliament, and it's a proper thing. And then, from, I think it was in Derbyshire, when they started to make these proper factories after the Industrial Revolution in Telford and so forth, people were kicking off about money, right? About, minimum wage and so forth. And then that was the real, they did do a petition, but it was, Parliament didn't act on it. Parliament did not raise the minimum wage. And at that point, there's a lot of crime going up. They formed the Met Police. I've done videos on this before. They made the Met Police force, became a proper organised force. They got rid of arrests for civil causes. Our role to play in law enforcement was removed. And I think the Luddites kicking off and really pushing the boundaries, smashing the machines up, they got hung. They didn't end up proving protection extending to criminal damage, which got the Malicious Damage Act as well, right? The Malicious Damage Act comes out as well through this as a result of all this. But then you see you've got all these events with Parliament burning down, and then you've got this kind of like Denman. The Whigs basically, write some books. They make the Parliamentary Papers Act with a certificate from the Speaker, because up till you didn't need a certificate because your petition was your document. And remember, they get put in the Speaker's bag, so it becomes a document of it becomes a parliamentary document when it goes in the Speaker's bag. The petition itself, is meant to go in the Speaker's bag, so it's evidence of itself. So this whole Denman thing, and then we've got Sir Robert Peel with his police force, right? And then we've got Sir Denman is kind of upholding the rights, but the whole government, he's creating this massive, proper organised police force then, and removing us from, getting involved really in law enforcement directly. And they also scrap all this arresting for civil, for debt, for civil causes, which is probably a bigger deal than acknowledging the right to petition immunities, because there's a hell of a lot more of civil arresting going on in civil cases than people who are bothering to doing parliamentary causes, right? Some people aren't too bothered about politics. So Denman's, all this discussion and debate in Parliament around privileges as well happens, and to do with particularly to do with publishing items, publishing things. People have been, you see, from 1688, we've got our own rights, so we can publish it without being prosecuted, okay? But it was Parliament who got prosecuted for the Hansard thing, right? At that point, they don't have like a website that you go and put stuff on, and we do it ourselves, so it's between you and the publishers. So it would have been important to use that document. But no one had been prosecuted. No one had actually been prosecuted for publishing anything parliamentary or petitioning, because everyone kind of knew that it was from 1688 Bill of Rights. It was like full-on bona fide, officially protected, right? it was only since this, and I think that this whole Hansard issue, Messer Hansard case, I think it was another publicity stunt. It's almost like it was kind of arranged or whatever. Maybe it wasn't, but so effectively, So, and then what happens is you've got all these acts coming out later on, like, the Public Meeting Act and so forth, which actually really stands up for our rights. And that then you come into the suffragettes, and I think the suffragettes had a lot less problems. They had that woman who ran out in front of the king and got run over by his horse. But apart from that, when it came down to rights, I think the suffragettes had all the full rights behind them because it was all proper. At that point, it was all acknowledged, used, understood. They got all the law books. It was all relevant. Now, the thing is, the election petitions, and because of all this arguments over suffrage and women voting and kind of like the factory workers kicking off about the wages and the whole thing kind of flowing from the early to mid 1800s. And then it took the suffragettes 100 years, I think, to get their issue sorted out. As we flow through that 1800 period, and then they're also taking they're scrapping juries in civil cases and at magistrates court level as well at that time. They're actually there's some laws made which really protect and enforce this political right. But what you actually see is the undercurrent of it is they're actually, while Denman is kind of like, coming out with these Parliamentary Paper Act certificates, and while we've got the Public Meeting Act and all things like that, and kind of acknowledging privileges which the suffragettes used, while they're doing that, they're actually stripping back a lot of powers by, removing judicial power, us not engaging directly in policing and enforcement and getting an organised force to take control of it. And then us not really in the courts so much with juries, when previously from 1688 and through the 1700s, they had these courts of conscience, right? So there were, I think the 1700s, with courts of conscience, particularly with civil cases as well, and things like that. So I think, by the time you've finished with the suffragettes and the women have got the vote, but everyone's voting Labour, or Tories. The women have this massive vote to get the vote, but what's the point of women fighting to have a vote when there's only like two or three options worth voting for, By the time they finish fighting for the right to vote, the Labour Party, you've got everyone voting Labour, right? So, if you're poor, you vote Labour. And if you're affluent, you vote for Conservative, right? And then by this time, had very few people vote Liberal. What's the point? I mean, what is the point in all these women, right, fighting for the vote, particularly working class, when the whole working class pretty much votes Labour? At least, they did in Manchester and in Leeds and in, Birmingham and in these like inner city areas. It's if women fighting for a right to vote just so Labour Party can get more votes. So the cunningness of it to arrest all those people into one single vote for one party and claim it's sticking up for them. What was the point? It's not like there's, if there were some more options, if there were like 5, 6 or 7 different things to choose from, then fair enough. But when there's like, mainly, Conservative, Labour and the Tories, it seems pointless them. I mean, if Labour are going to win, maybe it's what gave Labour the power to get into government, but, if each area, is that only so the women in each area can get themselves a Labour Party representative in? But if they're all going to vote for the same party, what's the point? And this is when I think, independence. And I actually think that, this all, can we form a government? It's tosh, you get into government, you have a speaker. And if these people can't work with each other, to decide, who's going to be the Prime Minister and form a cabinet, they need to learn to work with each other. In this day and age, right, it must show the social disorder if if the society that these people have built and created is that good, then surely, if you pick, a random bunch of, 500 people, if they can't get on with each other enough to form a government, and they all have to be from the exact same political party, then it shows, how can these people work with anyone? How can they work with the public? How can they run anything? If they, why do they have to be from the same party? And I think that it's a big con. They've all got to be Labour in order for them to be able to form a government, or they can't get on with each other. It just shows, it makes you wonder, are they fit to be MPs? If people in Bristol and people in Plymouth and people in Exeter and people in Kent and people in, London and all over the country vote for the person they want to be in government, right, on their personal characteristics, their personal character, their personal integrity, their personal competence, understanding, skills, education, right, and so forth, and willingness to represent their local people. If Parliament was filled with people of that calibre, right, to say that they would not be able to come to an agreement and work together and form a government would be preposterous, because it would mean to say that they can't get on with people. How are they going to get on? How do they get on when they go to an AGM meeting, unless it's the same company? How do some of these companies get on with each other, if they're not from the same company? It's almost like saying, if a company's not owned by BlackRock, then, we can't cooperate with you. If the widget factory, if all the widget factories, subsidiaries aren't owned by BlackRock, then we can't run a business, Well, we can't do deals with, steel workers unless they're owned by BlackRock. We can't do deals with, water suppliers unless it's run by BlackRock. It's like saying that, can anyone get on with anyone? It's a miracle that kids, at school can get on with each other, if they're not. I'm quite surprised that we didn't end up actually with a swearing in at school. Like in America, they all do the swear allegiance to the flag. I'm quite surprised that we didn't actually end up, like some kind of, like everyone wants sworn in, because, you don't even have to take the oath of supremacy in court to give evidence. All you have to sort of do is swear to tell the truth. Although you do mean to swear it on the Bible, but that's the thing. So anyway, Prynne. So William Prynne, he's a really important writer when it comes to political law and rights, and he had a lot of influence in both. To what his books have influenced the Tumultuous Petitioning Act and the 1688 Bill of Rights, if you understand and read them properly, and know that those books would have been known of and recognised. Now, the thing is, since Denman, you see, that's another thing I wanted to say. From like Sir Robert Peel and Baron Denman, from then on, you see, you've got Sir Thomas Erskine May. And his book's been adopted by Parliament, and it's taken as the go-to book now, you see. And then, but what they're doing is they don't really want people to know about William Prynne. And even now, they don't really want people to really know too much about Baron Denman's acts and works and so forth. And now, with Parliament basically been denying that it exists and denying that it's a right, it's all been subdued. But that really came about from the miners' strikes, because the miners' strikes was a political period which was a lot later than the suffragettes, but that's when the Crown Prosecution are formed after that, and they really, from then on, it's like, they've written them off. They don't want to acknowledge the existence of political immunities or protections for us. They're off the radar. They've replaced it with a word called protesting or demonstrations, and it's got nothing to do with our Houses of Parliament or the King. It's just, working class people doing unions and knocking about against their employer, right? Because when it comes to politics, and you just leave it all to the Labour Party and Tony Blair, right? Or whatever, after Scargill. So, and then what you'll find is, I've got a book in front of me now, and this is a book that I want to do a video on. I've just got it now. It's the Parliament Manual, and I'm reading the petitioning section, and I'm going to do, my next video is going to be some critique on it and the attitude that's in this book. But this book is, let me see, I think it's 1980. Oh, it's 87, right? So 85, 86, 87. So it's actually the year after the Tumultuous Petitioning Act is repealed, okay? And that's actually quite an important, it's a very, very important event, that repealing of the Tumultuous Petitioning Act, because, you know, William Prynne had a part to play in it being made. And also he did, actually his books also did influence on the 1688 Bill of Rights as well. And there's, how many pages is there here? There's like there's only 4 pages. It's the rules for petitioning. And this is like, remember, that it doesn't say anything about privileges at all whatsoever. In fact, they've pretty much put the nail in the coffin with it and made it sound like petitions to Parliament are extremely insignificant, extremely unimportant, and not really much worth doing. But they've got like about, I think they got 4 pages on it, and that's going to be on my next video. And I'm going to critique some of the things that I think they've got wrong, some of the things that they might be lying about, and also, you know, it's this attitude here. I don't know what the previous books were like. It'd be interesting to see the ones from the 1960s or 1970s, but this one for sure. This is 1987, and this is the Crown Prosecution Service have been created and formed 2 years before this, and then the year before this, the Tumultuous Petition Act was repealed. And in this book, it does make petitioning sound extremely unimportant and insignificant. But there's actually a lot of things in this book that you can query. This book also does quote, it draws from Erskine May, but it doesn't draw anything from Baron Denman's work or from William Prynne either. Or even from Broome, from Herbert Broome. You see, I forgot to mention Herbert Broome as well in this video. Herbert Broome plays into... Herbert Broome supports and upholds what Denman did and the truth and fact from the 1688 Bill of Rights. And he's backed up and supported, you know, by Denman's fourth son. And all that is carried on through, really, up until this book that I've got now, this parliamentary practice book time, which is kind of like just after the miners' strikes. At that point, then they've pretty much deserted us, and they don't want it really to be properly acknowledged or to exist. And I think this book, really, the insignificance that this parliamentary manual puts on petitioning, following the repeal of the Tumultuous Petitioning Act, it's clear that they hold the entire procedure in utter contempt. It's not really then. I think pretty much from 1987, I would say, you know, I mean, when I grew up, I'd never even heard of petitioning before. I didn't even know what it was, right? So I think that they're pretty much following the miners' strikes and the whole, the whole kind of like early Labour sort of kind of like uproar to do with the unions and all that. They pretty much put it in the coffin until Tony Blair. It's Tony Blair's government then which kind of like gets it back out of the cobweb closet and then says, oh, we'll do a website, right? So obviously some people must have heard about it or known about it. Now, I don't really know why Blair did that, because in a way it's a good thing, right? I'm not knocking Tony Blair for doing it, because, you know, it's like draws attention to it and it modernises something, and it's something that people can engage in. But I didn't know about it in 2006. Looking at the graphics on the website, it looks quite pixely. I know that I was active on forums around 2000, 2005, 2006. Maybe it was quite, maybe the government were holding back on the kind of like, graphics and the whole look of the website, but I definitely didn't see anyone sharing any petitions. At that point, there wasn't really Facebook or YouTube or anything like that. It was forums. People would go in forums, so you would find all these forums that people have got these like websites and administrators, and they were all private. They would probably share them in places like that, but a lot of it was to do with bulk emailing, right? That was the big thing. because he used to get all these spam and junk emails around that time, 2000, 2005, right? So it was getting hold of these big bulk email lists. If you could get hold of one of those big email lists, subscriber lists, you were onto something, because then you could send out these mass emails to people and get one of those bulk email programs. Now, I think it's likely that when they did that petitions website on Tony Blair, number 10, I think there will have been a Labour Party or Tory kind of little scam going on, because they had a lot of members to their parties, you know, who would join and they could get access to emails. A lot of businesses and companies had access to emails. So my hunch, I haven't actually read a lot of the petitions from that website that they're on. I've seen the list, because there were a lot of local petitions from local areas and local groups, and now they're trying to make out that you can't petition for local matters when you can, because the 2010 Act made it so that building and planning aren't to be considered as a local petition, so therefore there's nothing a local matter, so there's no stopping you from petitioning Parliament about it, right? But they repealed that, but they'd actually openly said that it's not going to be considered a local matter, right? So the thing is that, I mean, I think, I mean, I don't know, it would be interesting to see which petitions got debated and which petitions got backing behind them. But the thing is, if you've got a political party and everyone's voted for you, and, you know, they're all coming to the local surgery and they're all backing you up like Tony Blair's government, why would you need petitions? There might have been some certain things that would have been harder for them to get voted through or put through government without a lot of public support and backing for each individual case by case basis, you know. So I would be interested to know the statistics for those petitions and what subjects they were and what things got put through. Not that it would have, you know, it didn't stop, you know, Gordon Brown from selling the gold off, did it? You know, or from him making the Constitutional Reform Act or whatever. But I'd be very interested to know who signed those petitions and if it was through these emailing lists, you know, these kind of like bulk email lists, and if it was a lot to do with, you know, Conservative and Labour membership. Maybe it's not, maybe I'm wrong. But that's just something that is, you know, I'm curious. They might not have needed it. So the petition website, but the thing is, what they do with that petitions website is that they bring it kind of like under, into the remit of sort of Parliament. To when you're writing it and drafting it and creating it, they're making it like a government process, which it is, but by us, by you. So now the thing about these rules I've got out in front of me, which is something that I'm going to do in the next video, but it's like, it says that a petition has to be handwritten. Now, if this is the thing, I've got some specimens that I picked up on eBay, which were put in the newspapers, right? Or printed out in leaflets and pamphlets by big companies or by people who put it in the newspaper. I think one wasn't by a member of the House of Lords, but you can actually, it's the petition, but you can sign it yourself. So like the newspaper might have like quarter of a page of a newspaper, and then you can get like 10 or 20 people to sign it, right? Or they could do it on leaflets. Now, the thing with that is you might say, well, it's not handwritten, it's printed or lithographed or whatever. In this book, it says that the main part of the petition has to be handwritten, but it said subsequent sheets can be printed, like with the signatures. So that would provide or facilitate for separate sheets. But it also says that you cannot annex any other document onto it or annex any other evidence or affidavit onto it. But you can't annex an affidavit onto it because it is an affidavit in a way, because an affidavit is only a complaint. And a grievance, you can have understanding order 155. A grievance is in acts of legislation, like in 1837, an affidavit, they've got the form for an affidavit and it's written out like a petition. It has to be written this way, right? And it actually says, at the top, it says complaint. So it's a complaint against someone breaking the law, a criminal matter. It's a complaint about a citizen, right, to the executive, to the government, right, to the corporation, you know, to the mayor, to the corporation. It's a complaint to the corporation. It's a complaint to the executive, to the king, to the government, right? It's a complaint. It says complaint, right? That's how it's written. So when they say you cannot annex an affidavit to a petition, but it says a petition can be a grievance, well, that'll be it. That's the affidavit, right? So it's quite funny, and then it says, you cannot annex any other documents onto it, but then it says that the petition must be handwritten or printed, but any other additional sheets, like with the signatures on, can be printed, and so forth. Well, obviously not that when you sign it and write your name on it, they're all in writing, because if you cut it out of a newspaper, right, and 10 different people sign it, they're all going to be individual, unique signatures, right? But what he's saying is that, but they would all be separate sheets. So, but that's evidence. You're annexing evidence onto it, because each sheet of signatures is another sheet of evidence of people supporting it, right? Even though the original's handwritten, and they all have to have it like written on the top of it what it actually is, right? But that's multiple sheets, So, and the thing is, when you read this book, it's trying to make out like it makes people think that there's no such thing as annexing evidence. There's no such thing. It doesn't exist in the process or procedure, or it's never existed in the process or procedure. Like it's never, it's got nothing to do with it. It's not something that associates with it or that you do for it, but that couldn't be further from the truth. It is and was and always has been from the start something that you do with it, because it's like any other criminal or civil case, a case as evidence. All they did at one point is have a resolution in Parliament that they didn't want any evidence or materials annexed onto it anymore. And I would just simply suggest that, it gets lost. It could get separated, and particularly with the burning down of Parliament, and they stopped saving the documents, then, so it was something to do with it. It was part of it, but then they put a standing order. But the thing is, this is now 2025, with state-of-the-art technology, modern times, digital, what burden or, how, you're unlikely to get something separated from the petition now because of technology, because of, emails, files. In fact, it's more secure. So, why do you need that standing order anymore? Fair enough, if there's too many documents clogging Parliament up, but everything's digital on file now. Evidence is part of a claim. Evidence is part of a case to prove it. The only reason now, in this modern 2025 digital age, where you would say, we don't annex evidence to petitions, is if you did not want them to win, if you did not want them to succeed, if you did not want them to prove their case, which is something that, I'm going to go through in this other video. But so William Prynne is a very, very, very monumental and important writer when it comes to this type of parliamentary process and procedure. And his work has fed in, actually, to a hell of a lot of effect on everything else. And likewise, Herbert Broom as well. So it's actually, really, it's, 1986, 1985, 1986, and the miners' strikes period time, which is really actually what put it all in the closet, really, put it all away until Tony Blair got it back out again, really, with his Number 10 website. But in doing so, they arrested or brought under their control this preparation of the petitions and the sharing of them, right? When it was really... Now, if there weren't a lot of people doing it, if there weren't a lot of people putting them in the newspapers, if there weren't a lot of people who knew about them, if there weren't a lot of people going door to door, then fair enough, right? Why would Tony Blair draw attention to it? Well, the thing is, if people just stop doing it on paper, or there's no point, and everyone does it electrically, right? Emails, e-petitions, online, then what they're doing is they're even phasing out doing it yourself, DIY, kind of like doing it in hand, by print, by writing, and by newspaper or whatever. And the thing is, okay, you can share it online now because we've got technology. They've still got 38 Degrees and Change.org, but a lot of those, Change.org's all foreign, so like they don't accept foreign signatures. They don't let you have the emails, you have access to the bulk emails and so forth, because those sites like a monopoly of all the emails, right? And that's what would have given you the power in 2006. In 2006, that would have given you the power to get big email lists and bulk email people, right? But the two independent websites that are most well known, their administration, their operators really don't like you getting in and having the emails, when really it can't be valid without the email address. When I've downloaded the spreadsheets, it doesn't have all the emails on, right? So with those two main websites quite safe, protecting 38 Degrees think they're doing a wonderful job. They're the bedrock of democracy. They're running this website, but they don't want you to have your own emails of your own petition. And how do you even know if they're legitimate or not when you can't see them or check them? I had mine. They disqualified me and removed my petition, seized it unlawfully because of some dodgy signatures that another person put on there. And I couldn't even check those because it was impossible. It wasn't my fault. So 38 Degrees aren't really... it suits some people, but they pick and choose who they help as well. And really, they're helping the government prevent people from getting, access to these emailing lists. And when it comes to sharing on Facebook and YouTube, they've got a lot of heavy restrictions on there, like messenger restrictions, and then they've got other group administrators. It's almost kind of like... what do you call it? This whole principle of blockchain, right? Because you, in a lot of groups, you can't post if you're a page, or the admins won't allow it to be approved to put on there. So they've got all these blockchains of persons, key workers, who are impeding progress, and then people sometimes aren't interested until you and this is the thing. So there are really a lot of obstacles until this e-petitions website that the government have got, and they think that, this is great, this is a solution, or this is the answer, but they're disallowing everything, right? Now, it says in this book in front of me, it says that there are certain things that, that the clerk of the journal office is supposed to check, but actually, it only gets returned to the MP, it doesn't necessarily get returned to you. In fact, remember, they were destroying all the original ones. They weren't definitely sending them back to people because, people would still have them. Maybe there'd be a lot more of them existing if they had have sent them back to people, right? Apparently it gets sent back to the MP. But this is the thing with the criteria. They don't actually tell you what to write or change your writing. If it's not acceptable, then they just don't debate it. That's it. And the problem with the website is that... They're actually emailing you and they're telling you you can't have it written like that, but you can have it written like this. So what he's doing is he's telling you what to write, and he's suggesting, what to put. And in here it says that a member must not present a petition from himself, right? So If Jamie Stone MP, for example, has written to you and said, I don't know what you're asking, or, you can't say that, but you could have maybe tell Tony Blair he smells of, pineapples, right? So he's actually even proposing what your petition is going to be. So if you actually write that and submit it, it's actually, that is the words from an MP. That's his petition, not yours, right? So that's actually illegal. So there's a lot of things that they're actually doing at the moment which it's unlawful, and they actually cannot. They're not to have a hand in preparing it, and they're not actually meant to share them, because hosting them, right? What they're actually doing is they're publishing it before you officially hand it in. And they're controlling the processes of pre-debate, that's all under your control, right? And what they're actually doing is they have published it, okay? And they're the one who's sharing it rather than you sharing it in the newspaper under the right to petition, okay? And what is really annoying is that it is published by Parliament, but before it's handed in for debate. And they're not even... The Speaker of Parliament, he won't give you a certificate to say that it's published by Parliament and protected, yet they're wanting to publish it on Parliament's website before the debate, not after you successfully get it debated and it appears in the books in Hansard, right? Or on some MP's website or whatever, which is insane. They've taken the publishing off us and given it to themselves, and publishing it officially on the website before it's officially completed and handed in, and they're not letting you collect the signatures to compel them to debate it. Because they're calculating it in what's best way for them. Because they're figuring like, well, if we're not going to accept it with one signature, then we're not going to accept it with 1,000,001 signatures, right? If it doesn't conform to the standards. But these standards are only meant to be like general etiquette and so forth. There's another rule here that says you can't ask for a motion. I don't know what it means by that. If it means that you can't ask Parliament to actually make an act of law or put anything through or do anything, then they're definitely breaking that rule, because that's the whole thing that it is. But they're not actually allowing any petitions on there of grievances or with accusatory claims in there. And that, from this book in 1987, it seems that it's all either accusatory petitions or... not really for getting laws made or changed. Now, maybe I'm wrong about that. Maybe it means that, like, motions in Parliament mean that you can't petition for the MPs to vote a certain way or how they should vote. Maybe it means that, or you can't petition for a particular decision or outcome. But you could say, like, I think it might mean that, if you want, if you want them to make a law to ban smoking, for example, right, you can ask for that law, but then you're just asking for the law, right? Otherwise, like, because they've got a separate thing for bills, haven't they? Because bills are legislation, so you can definitely put bills through. But when it's a motion, I think you can put a draft bill or you can ask for an act, but I don't think you can, like, petition. I think it means that, the part, but the MPs, the kind of voting and so forth and certain things, I don't think you can get involved in the things that are reserved for MPs, the things that MPs have the right to do themselves, which is their privilege. Our privilege is the preparation and collecting the signatures. So, but it's been taken over now. So by the committee, unlawfully, they aren't allowed to stop you from collecting signatures freely, and that's what they're actually doing now. So